Welcome to Introduction to the Rule Against Hearsay. This is a short video that will explain the rule against hearsay as it operates in the trial context. In this video we'll cover what is the rule against hearsay, why we exclude hearsay evidence, and we'll work through some examples of the rule against hearsay in practice. Witnesses in court give oral evidence under oath, and when they give their evidence, they're subject to cross-examination by barristers for the other side. In this way, we test the veracity of their evidence and the reliability of the witness themselves. Witnesses are allowed to testify to directly observed facts that they observe using their senses, such as hearing and sight. However, when it comes to statements overheard by the witness, but made by somebody else, some restrictions apply. So hearsay terminology involves the declarant, which is the person who made the original statement that the witness is now reporting on in court. It can be a written or oral statement or a statement by conduct. A hearsay witness hears or observes or reads the statement and reports it to the jury, and the jury cannot observe the maker of the statement. So the definition of hearsay. Hearsay is an out-of-court statement offered in court by the witness in order to rely on the truth of its contents, so to prove some fact that's contained therein, and not for some other purpose. For example, in order to prove the fact the statement was made, for example, in a scenario where a person claims they cannot speak, that's original evidence. So why do we exclude hearsay? Hearsay is seen as inherently unreliable evidence that may mislead the jury because the evidence is unsworn and the maker of the statement is not tested in court by cross-examination by an opposing barrister. So the danger is the jury may be unduly influenced by it. Here we have an example of the rule against hearsay in operation. So in this case, the accused was charged with unlawful possession of ammunition. He pleaded duress that he had been threatened to hold the ammunition by terrorists who had threatened to kill him. Could he give evidence of the threats of the words used by the terrorists? So applying the rule against hearsay to this situation, the witness wants to repeat in court the out-of-court statement of somebody else, the terrorists in this case. So we have to examine the purpose for which he wants to introduce that evidence. If he wanted to introduce that evidence in order to rely on the truth of the contents of the statement, i.e. that the terrorists really did intend to kill him, then the statement would be excluded as hearsay. But that's not what's at issue in this case. What's at issue is whether he was in fear. So the statement can therefore be introduced not in order to prove the truth of its contents or whether the terrorists intended to kill him, but rather to prove the fact that it was made, so the fact that he heard death threats and therefore was in fear of his life. So it's admissible as what we call original evidence. That's the case of Subramanian versus the public prosecutor, so a UK case on hearsay. So it's crucial when examining a hearsay statement to examine the purpose for which the statement is sought to be admitted by the witness. Why does the witness want to give evidence of the statement in court? If it's to rely on the truth of its contents, then it's hearsay, and it's inadmissible unless one of the exceptions to the rule applies. If it's to rely on the fact that it was made, then it's not hearsay, it's original evidence, and therefore it's admissible. So finally, we have an example here of a hypothetical scenario. Deborah is suing Perry, alleging Perry's dog bit Deborah's 4-year-old son, Tommy. Deborah wants to give evidence that her son told her after the incident, "The neighbour's dog bit me on the leg." Is that testimony hearsay? So if you take a few minutes to select one of the answers A, B, C, D or E, either yes it is hearsay, no it's not hearsay if Tommy testifies later to confirm the statement, no because it can be used to prove that Deborah believed Tommy was bitten by the dog, D, the judge can give a limiting instruction telling the jury not to use this testimony as evidence that Tommy was in fact bitten by the dog, or E, no because it's not an out-of-court statement. So in this case it's clearly an out-of-court statement. The purpose of introduction of the statement is to prove that Tommy was bitten on the leg by the dog, which is a fact and issue in the case. Therefore, the statement falls within the rule against hearsay. So the answer is A, yes it is hearsay. The statement is only relevant to prove the truth of the matter asserted, specifically that Tommy was bitten by the dog, since there's no other relevant use of the statement. Therefore, it is hearsay. Thank you for listening.
Determining hearsay admissibility is thus a 5-step process. It begins with the definition of hearsay. First, is there evidence of an out-of-court statement? Second, is the statement offered to prove the truth of the matter that it asserts? If the answer to both of these questions is yes, then the evidence is hearsay and will most likely be excluded by the rule against hearsay. However, third, the statement may fall under an exemption that makes it non-hearsay. If so, then the statement will not be excluded. Fourth, even if the statement is hearsay, it may still fall under an exception to the rule against hearsay. If so, then the statement will not be excluded. Fifth, remember that even if a statement does fall under an exemption or exception to the rule against hearsay, it may still be inadmissible due to the right of confrontation under the Sixth Amendment. We'll learn about these steps in more detail in the following clips of this tutorial.